The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, April 13th, 2016 are currently trading with gold at $1,246.13 an ounce, silver $16.29 an ounce, Texas crude $42.17 a barrel, and Bitcoin is currently sitting at about 426 U.S. currency. Today in history, the year 1970, the Apollo 13 astronauts announced, "Houston, we've got a problem," as a result of a beach-built oxygen tank exploding en route to the moon. The beginning of the Apollo 13 crisis was 46 years ago, today in history. In recent news, more than 400 protesters were arrested last Monday outside of the U.S. Capitol from an organization called Democracy Spring, which is seeking to remove special interests from politics and raise awareness for change on restrictive voter identification laws. The demonstration resulted in arrest for what U.S. Capitol Police deemed unlawful demonstration activity, such as crowding and obstruction. Apparently, the protesters were sitting on the stairs of the east front of Capitol Hill. Democracy Spring said on their website that the protest was held to demand Congress take immediate action to end the corruption of big money in our politics and ensure free and fair elections. Peter Callahan, the group's communication coordinator, stated that, quote, "We see populism on the rise on both sides of the spectrum. Americans are sick and tired of their politicians being bought and paid for. Organizers are vowing to continue the demonstration every day for the duration of a week." The Pentagon declared today that the first phase of military operations against the Islamic State in Iraq and Syria are now over, and that the second phase is being implemented. Colonel Steve Warren, the spokesman for the U.S.-led coalition fighting ISIS, stated that Phase 2 is aimed at dismantling this enemy, while Phase 3 is ultimately the defeat of ISIS. Success in the first phase included the recapture of about 40% of the territory ISIS once held and the annihilation of key leaders and revenue sources. The second phase, now underway, is focusing on fragmenting ISIS and liberating key territories under their control, like taking back Mosul in Iraq and isolating Raqqa in Syria. The Lone Star Lowdown is currently looking for sponsors. If you have a product or a service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This has been Rick Rohde with your Lowdown for April 13th, 2016.
Okay, howdy. This is Randy Kelton, Deborah Stevens, Rule of Law Radio on this Thursday, the 14th day of April, 2016. And we have the phones open. We'll keep the phones open all night. If you have a question or a comment, give us a call, 512-646-1984. I'm going to start out with a little more about Weatherford, Parker County, Weatherford, Texas. I have a woman there who took on the right to travel issue. And I've been called there before over the exact same issue. I had a friend out of Waco that they put him in jail there. They were going to keep him there for 6 months. And I went down and looked at the records, and he had filed a habeas corpus, and there was no return on the habeas. So I sort of made a big stink about it, and a couple of days later they got him out of there. But I guess they scared Mark so bad that they scared him right out of the movement. I haven't heard from him since he got out of jail in Waco. And I can't say as I blame him. But now they have another woman in there, and they gave her 90 days. And I went and looked at the records, and I found in the record that the prosecutor filed a motion in limine. And a motion in limine is a motion asking the court to restrict certain things being brought before the court. Essentially, a motion in limine goes to all the things you can't say. And in the motion in limine, they ask the court to forbid the defendant from bringing any law or case law concerning the right to travel into court. And the judge approved it. And then in the charge to the jury, the judge made up a definition for motor vehicle and for travel. He made up definitions that didn't exist in law. So we're going back after him. They've got the woman in jail, and they're trying to hold her in jail. They gave her 90 days and gave her 3 days per day so she could serve it out in 30 days. Just long enough to get past the time where she could file a motion for appeal. First day in there, she asked for a form to file for notice of appeal. They refused to give it to her. So she filed a grievance against the jailers. Every day she asked for it. They refused. She filed a grievance. Well, when I finally found out about it from her husband, I went down to the sheriff's office and called the sheriff's office and got a hold of a sergeant there and asked the sergeant to arrest the assistant warden. Accused the warden of acting in concert and collusion with the judge for the purpose of denying the person access to the courts to prevent her from being able to appeal this bogus conviction. And within 2 hours, I find out that the warden ran down there with this notice, this form for notice of appeal, and had her sign it and apparently got it to the court. Well, when I talked to the sergeant, I told the sergeant I wanted him to take a Class A misdemeanor official oppression charge against the assistant warden. And he said, well, you'll have to talk to the jail. Well, the jail is a private jail, and it's manned by certified jailers, not certified peace officers. So I assured him I could not take my complaint to the jail as they were not peace officers, and therefore could not act on my complaint. And he said, well, you'll have to take it to jail. So if I bring you down a verified criminal affidavit, am I to understand that you're going to refuse to act on it? You'll have to talk to the jail. Okay. So after I told the sergeant that, apparently he called this assistant warden. And that's when she got these documents down to this woman. Well, the way I read that, that's shielding from prosecution and obstruction. They conspired one with the other to shield her from prosecution from the act she'd already committed. I guess they thought if they run it down there and got it to her now, that somehow all of those other times when they denied it to her would somehow stop being criminal. That's like I run a red light every day going to work, and the policeman stops me and I say, oh, okay, I won't run that red light today. Well, now I'll take this to the district judge, a complaint against the sergeant for conspiring with the accused to shield the accused from prosecution. When you try to skirt the rules, everything you do makes it worse. Okay, we do have a caller on the line. We have Alan from California. Hello, Alan. What do you have for us today?
Hello. Can you hear me okay?
Okay, you need to move the mic a little away from your mouth. Move it down by your chin. You're really distorting the mic. Are you there, Alan? Well, it looks like you moved it too far from your chin because now I can't hear a word. I think perhaps we're having a bit of technical difficulty. I'll let our producer have a look at this. Or Mike, if you're talking, I'm not hearing. So you might try hanging up and calling back. Maybe we'll get a better connection. Okay. So since we've lost Mike for the moment, I'll go back to Weatherford. And this is working out pretty well. It seems that when we're careful and we back up and think about what we're doing, these public officials always seem to be incredibly accommodating. And if Scott is listening out there, Scott, you need to call in. We want to talk about what happened to you. Scott's been calling in. He's been taking them on in Dallas County, filing criminal charges. Well, he went to court yesterday, and he had put in requests for information about the judge and the prosecuting attorney. And they called him into a private meeting, and the judge told him that the judge felt threatened because he had asked for public information about the judge. Now, I would think that the judge would know better than that. That's witness tampering and obstruction. For her to indicate a threat against her in order to prevent him from seeking public information, and the prosecutor demanded to know why he was trying to get that information. That is absolutely forbidden by code. 552 government code forbids a public official from asking a citizen why they're seeking information. So that's a Class A misdemeanor. And then after his trial on the way home, the policeman that gave him the ticket, they sent him out to arrest him, and they arrested him, threw him in jail over a revoked or expired license. They had a problem with the license that was a DPS problem. And he's already went to court and got that corrected. And they came and arrested him for it anyway. So now it just seems to get worse. Now he'll go after him for false imprisonment, retaliation. And when he was saying, these complaints, they're building up. There's going to be so many of them, you can't hardly keep up with them. And that's what I find. Every time we go to a jurisdiction and take them on based on letter of law, they will give you more accusations to make against them than you can keep up with. Okay, we do have another caller. I'm going to try Alan again first and see if Alan is back with us. Alan, are you there? Talk to me, Alan. Okay, Alan, if you're talking to me, I am getting no sound at all. So if you can hear me, hang up and call back in. Okay, now I'm going to go to Kyle in Florida. Hello, Kyle. What do you have for us today?
Hi, yeah. I was calling. I've been trying to get in touch with somebody about right to travel. And I just called in. I haven't been screened. I was just wondering what your outlook on that is. Right?
Okay, well, Eddie does the travel show on Monday night.
Yes.
I know some about it, but I tend not to go directly to all of the issues because I'd be kind of stepping on his toes. He doesn't go into due process a whole lot because that's what I do. But I do know some about it. Have you pulled up the transportation code for the state of Florida?
Not.
Okay. If you are going to take on the right to travel, first and foremost, you've got to do your homework. And it's not as difficult as you would think. It's not a whole lot more work than reading the newspaper in the morning. You get up in the morning and spend 30, 40 minutes reading the newspaper. You spend that much time reading the transportation code, and you'll know more about it than most of these police officers do.
Yeah.
Now that is pitiful. It's horrible that I can say that on the air. That is actually the case. Hang on, we're about to go to break. We'll pick this up on the other side. This is Randy Kelton, Deborah Stevens of Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Kyle in Florida. And, okay, read the code first.
Yes, sir.
This can be a lot of fun. You go into court and you have no idea what's going on. And they pull all kind of garbage on you.
Mm-hmm.
And it's really frustrating, intimidating. But when you go read the code, and the way I suggest you do it, is there's two things you need to look at. You need to look at the transportation code, and you also need to look at the implementation of the code. You find such cool stuff there. Here in Texas, we have a Department of Public Safety, and they are kind of like the state police, but not really. You know, I was in Illinois, and we had a state police, and they really were state police. They had policing powers statewide. But in Texas, we've got a Department of Public Safety, and they're traffic cops. They don't really know that they're traffic cops because they didn't read the code. What the administrative code says, where the administrative code created the Department of Public Safety, it says the Department of Public Safety shall not enforce the criminal laws except at the request of and under the direction of local law enforcement.
Okay.
Reason being, they're just traffic cops. They are police officers. Real policemen are peace officers. So look in Florida's code.
Okay.
First take the transportation code. You don't need to read all of it. You need to read the implementation part, the front part of it. And don't try to read it and understand it the first time. Just read through it.
Okay.
Just cruise right through it. And then go back, read the first 4 or 5 chapters, and then go back and read them again. When you read them the second time, because you've already read past where you're at, and you come back and do it again, you'll start linking all these pieces together, and they begin to make sense to you. Anything that you're charged with, read it. Read the code. Read what constitutes a violation. Look at all of the elements and make sure that all of the elements have been alleged. If they just said you were speeding, not enough. Look at the elements of speeding. And, in Texas, Eddie would have more knowledge of other states' traffic code than me, but in Texas, the Texas Administrative Code specifically states that speed limit signs are for the regulation of commercial traffic.
Okay.
Now, look in Florida, see if they have something similar. And they probably do. Because
my charge. Go ahead.
Go ahead. You have to understand how this came about. Well, at least in Texas, the reason they started licensing drivers is because back in the 20s, when we first started getting functional cars, and then once they got cars, people started taking these cars and turning them into trucks. And then Ford and Chrysler and a couple others started putting out bigger equipment to use as trucks. Well, these things were an absolute disaster. They didn't have brakes. They had nothing for safety. And they were so heavy, they were destroying roads and destroying bridges. So the state had to do something to get this under control before everybody killed themselves. So,
right.
Well, at the time, everybody, Texas was open range. And because we were open range, everybody fully understood the right to travel. And you could travel anywhere you wanted to, and nobody could interfere with you. Even if you were crossing somebody else's property, you could do that because you had a right to travel. And everybody understood that. So when they first started putting in this licensing, they couldn't mess with people who were just traveling because the population would have had a fit. So they started licensing commercial drivers, and they gradually pushed this toward everybody. They kind of snuck up on us with it, and they brought it on kind of slow, and the people didn't realize what was being done. When it was first put in, most people were horses and buggies, and they fully understood that they needed some kind of regulation over these newfangled gadgets because they're scaring the heck out of my mules. So they didn't raise much of an issue. And by the time we had enough vehicles that the mass of the population was able to secure a vehicle, these licensing procedures were already in place. So they kind of snuck up on us.
Okay.
Well, now go back and read it. Now it's time for us to sneak back up on them. So first thing is read the codes. Read them Read them twice. Read them quickly. You don't have to study them really hard, because once you've read through them a couple times, you get into court, they'll bring up a code, you'll remember it. And you can take out you need to have a copy of the code with you. Take it out and check it, and you start taking them apart on code. Then they get flustered really fast. It makes this a lot more fun.
Yes.
Okay, do you have a specific question for me?
Well, I mean, my charge is driving with a suspended license. At the time, my license was canceled. So from what I understand, from the research that I have done, is by signing your driver's license, you give up your rights and you enter in a contract with the state.
No, you don't. Hold on.
Okay.
There's a lot of people out there saying that when you enter into a contract with the state, you give up your rights. Well, that's a really broad statement. I was pulled over in Austin, and this officer asked me for my license and proof of insurance, and I gave him my proof of insurance, and I gave him a Texas ID. He goes back to his car, and then he comes back, and he said, well, Mr. Kelkin, this is a Texas ID. I said, yeah, as a matter of fact, it is. Mr. Kelkin, do you have a driver's license? Well, he knew I did because he already checked. I said, yeah, I have a license, but I'm not using it right now. It's important we understand the distinction. And he said, Mr. Kelton, are you one of those guys? And I said, yes, I am. Here, have a nice day. So
yeah,
you were charged with driving without on a suspended license. At the time, how many people were you transporting for pay?
None.
How much product did you have on your vehicle that you were transporting for hire?
Absolutely none.
What are the elements that constitute operating in commerce in Florida?
I don't know. That's something I guess I should have done my due diligence.
Look that up, and your argument can be that, yeah, I had a license, but they got suspended, so I'm not performing commerce on the highways anymore.
And that's what I used as my argument. What I had found was a brief that was created, and it was online. It was right to travel versus driver's license, and that's what I had used as my basis. And I went in, I filed a motion to dismiss due to lack of jurisdiction, and the judge considered it. And I've never written a motion, so I don't know if he denied it because it wasn't properly written. But he denied it, and I go to non-jury trial. But basically, when we did the motion hearing, I basically told him that the definitions of the driver versus driver's licensing, and I explained to him that I was using it for my personal pleasure or transport.
Okay, hang on. We're about to go to break. Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
Are you one of the millions of Americans affected by a chronic lung disease like emphysema or asthma? Your next round of therapy could involve musical toe-tapping fun. I'm Dr. Catherine Albrecht, and I'll be back in a moment to tell you how.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Medical devices are not usually known for being fun, but French musician Frédéric Yonnet has found a surprising alternative to his old asthma inhaler, a harmonica. After years of chronic asthma, Yonnet picked up the harmonica and found his breathing dramatically improved. Pulmonologists say the harmonica is like bodybuilding for the lungs, and patients across the country are using it to ease their breathing troubles. Pulmonologist Mei Li Han explains, to play a song, you have to be able to take a deep breath in and blow out against resistance, which can help strengthen the respiratory muscles. That helps patients relax their breathing and learn to control their airwaves. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve, not beat and abuse.
Okay, we are back. Randy Kelton, Rule Law Radio, and we're talking to Kyle in Florida. Okay, Cal, where were we when I cut you off there?
I think we were talking about the motion that I filed. He considered it, but he denied it because I don't believe I wrote it out properly. And he set it for a non-jury trial, which is actually tomorrow. But
okay, hold on. One thing you should do is request findings of fact and conclusions at law.
Okay.
You want the judge to tell you why he denied your challenge subject matter jurisdiction, and he will probably refuse to give it to you because in a traffic case, your appeal is trial de novo, meaning that it is as if it didn't happen. But ask for it anyway.
Okay.
See if you can get the judge to tell you why he did it. He might tell you something really stupid.
Right.
Now, trial de novo needs a little bit of explanation. The court will tell you that when you appeal trial de novo, that it is as if the original trial didn't happen. And that is not true. It is as if the original trial didn't happen only for the purpose of perfecting appeal. If they commit any improper acts against you or deny you due process, that doesn't go away. Or if they say something stupid in the original court, when you go into the appeal court, you get to bring that in.
Okay.
It's called collateral estoppel. They can't take one position in one court and then take another in the second court. So if they take an illegal position in the inferior court, that's not necessarily before a judge who's a lawyer, and then they come before the judge who is a lawyer and they take a different position, you can stop them under the doctrine of collateral estoppel. So when you go in trial de novo, keep in mind what happens in the original court. You can still bring, if they make a stupid admission in the original court, you can bring that into the second court.
Okay. Well, so I guess another question that I have is we were also discussing the act of commerce, which I have already established to the court that I was not acting in or engaged in commerce at the time of the stop, the travel stop. So, I really am at a loss for where I go from here because.
First thing, don't worry about the trial court. Your only purpose in the trial court is to set the record for appeal. You don't care what that chump judge does. People go into trial court and they feel betrayed when, especially traffic of all of the courts you'll ever go into are absolutely the worst. They could care less what the law says. They will do everything they can to get you to feel mistreated and betrayed so that you'll never want to come back into that court again. So the next time you get a ticket, you'll just go pay it and you won't bother them with the trial. Because it's all about money. They're trying to make money. So they have to hold a trial that costs them money. So expect these guys to rule against you out of hand at every turn. Just expect it. All you're doing is setting a record. So go ahead, Judge. Do whatever you want to. And if you don't do it the way I like it, well, I'll just file a judicial conduct complaint against you. Let you dance with that. Raise your bond rating until they can't afford you anymore and they'll toss you out on your ear. You understand the guys in the traffic court? Mostly the judges are lawyers. And the prosecutors are obviously lawyers. Well, what do you think they're doing practicing down here in a municipal court?
In traffic court, yes.
They're not the sharpest knives in the drawer.
Yes.
If they were, they'd be out making the big bucks.
Right. They'd be, in the higher up courts, I guess.
Yeah, so these guys are chumps. And what do you think is going to happen when you bar grieve that prosecutor? Right. He's going to get apoplexy.
Yeah.
Because you're going to double his malpractice insurance. He's hardly making a living anywhere. He wouldn't be down here doing traffic court.
Right.
Then you sting him with a bar grievance, and his insurer gets it, and they double his malpractice insurance. That's like you getting in an accident or you getting a speeding ticket. That's going to make your insurance go up.
I see.
Well, his is too. His is too. But your insurance starts at probably $300-400. His starts at $25,000.
Wow.
And when his goes up, it really goes up. The judge, he's most likely check, make sure he's got a bar card and grieve him too.
Right. Well, I mean, this particular judge, I think, I don't know. I mean, to me, he seems pretty fair. I mean, he considered the motions, and he's kind of giving me a little bit of leeway as far as, what the prosecution asked a motion to strike because my motion wasn't properly signed or something like that. And he just basically denied her motion to strike and considered my motion. And and since it's a couple hundred miles from my residence, so he said he would need some time to consider it, and he let me go and on my way. And I just got a letter that's a couple weeks ago stating that he denied it, but he didn't give any grounds for what he denied it for. So,
okay, if you get a judge that actually at least gives the appearance of fairness, absolutely do not sting him.
No, and that's exactly what I'm trying not to do. But I don't know. Well, because I'm going in tomorrow and not knowing, why he denied it. Is there a way to?
No, don't worry about it because you'll bring the same thing up when you do the appeal.
Mm-hmm.
From traffic court, an appeal is always trial de novo, so you really start all over. So you'll file the same motion. This traffic court's practice, and you are going into the worst courts. Absolutely the most horrendous. They do the most horrible stuff. When you step out of that court into the county court, you step up a notch. Now, this judge is a real lawyer. He makes a lot better money than the municipal court judge does. And they tend to follow the rules a lot better. And this judge is more political because he had to get elected into this office. So they tend to be more professional. They don't tend to have as much of an attitude. And if they do have an attitude, you're in a position you can adjust it for them. And it takes a little bit to learn that, but that judge works for you in the end. I get in court and the judge raises his voice to me, I want him off that bench. If you cannot control your personal passions, you need to get down off this bench and have yourself replaced with the fair and competent jurist I have a right to in the first instance. I do not come here to be verbally abused by my public servants. Now, get down off that bench. I have done that a half a dozen times. And that is so much fun because always the judge backs up and he swallows his gum and he gets his act together.
Right.
They'll push you around if they think you'll let them. Some will. And then we actually have some good judges.
Yeah.
But with that said, these judges get people who are always angry at them. And they tend to kind of respond to that anger. So, sometimes I understand why the judges get frustrated and angry, but they don't have the right to do that. Hang on. We're going to have to move along very quickly because we've got a lot of callers. Hang on. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio, and Kyle. We do need to get moving along.
Yes, sir.
Don't worry about the trial court. Just use it as practice. The real action will be in the county court, and that'll be a lot more civil.
Okay. Well, I guess my final question, and we'll part ways. So when I go in, if he rules against me, and finds me guilty of driving while license suspended, what grounds what do I object on, or how do I make my appeal?
Oh, but you just start all over with the same. You file the same challenge, subject matter jurisdiction, or this will give you time to talk to Eddie and make sure your challenge is correctly structured, and you just essentially start all over again.
Okay. Well,
you don't appeal on this. You don't appeal on error because it's de novo. That's what de novo means. You don't have to go to the court and claim that the original trial court made a mistake in law or facts. You just start all over again.
So I file trial de novo?
Yeah, well, it will be, if you file a notice of appeal, the appeal will be trial de novo. This de novo is a matter of law. You don't have to say anything about that.
So if he wants to sentence me to jail time, because they were talking about 7 days in jail.
Wait a minute. This is a traffic court?
This is, it was the original ticket. The deputy didn't arrest me. He gave me notice to appear, and I guess it's circuit court.
Okay. So you're not in a traffic court. No wonder the judge is paying more attention. Okay, in this case, you'll have to appeal based on writ of error. You need to talk to Eddie and have him look at the subject matter jurisdiction challenge you made. That'll be your primary document that you'll stand on. But talk to Eddie. This is not just traffic. I've been talking about traffic court, and you're not in traffic court. You're in that second level court, and that's why the judge is paying more attention.
Right.
But to talk to Eddie, he can help you better than me.
Okay. And
thank you, Kyle.
Monday nights. All right. You're welcome. You have a good night.
Okay. Now we're going to go to Ted in Washington. Hello, Ted.
Hi, Randy. Thank you for taking my call. Can you hear me okay?
Yes, I can.
Wonderful. The reason I'm calling is I needed some advice about bar grievances. The situation is I have a prosecuting attorney who has mistreated me verbally over the phone. She hung up on me. That's one bar grievance. And then she's not responding to any email correspondence that I've been sending her. That's a second bar grievance. And I do have confirmation that the email was read, but she chooses to ignore me. The catch is she's going to be the same prosecuting attorney that I have on two separate tickets, two separate issues. But originally when I called her, I gave her both citation numbers, both ticket numbers. So I'm almost wondering, should I file 4 separate bar grievances for 2 for each ticket?
No. File only. It's not the number of citations. It is the actions that they perform. But make sure when you file the grievances that you file them separate and give a few days between them. If you make all of your accusations in one grievance, they'll treat it as one grievance. And they'll take the accusation they consider the weakest, deny that, and ignore the rest. So every issue for which you can grieve separately. It gives some space between them so they come in as physically separate accusations. Yeah. And that's not so much for the Bar Association as it is for the insurance companies. The bar may call them all one in that case, but the insurance company won't.
Understood. So I'll give a spacing of about 3 to 4 days in between the two separate issues. But my next question regarding this, should I put the case number into the grievance? There's a field on their website that asks for the case number. Should I or should I not? Yeah,
put it in there. But understand about the bar grievance, they're not going to do anything. The bar associations are just a public relations agency for the lawyers. For those people who haven't had to deal with these lawyers, they give everybody the impression that, oh yeah, we have an oversight agency. The truth is they don't have squat. So they're just there for show. So they're going to rule again. They're going to trash your grievance no matter what you do. So yeah, give me anything you want. You don't care. Except personal information is none of their business. And in Texas, when you get the bar form, they ask for a lot of information that's none of their business.
Okay.
Personal information, how much you make, who your neighbors are, that's none of their business.
Exactly, correct. It's just only facts pertaining to the case.
Exactly.
All right.
What they want to do is they want to pigeonhole you so they can decide whether or not they think you're credible. Well, the problem is, they want to find out if you're a high-level public official that's going to sting them good or something. But only give them what's relevant, because they're going to toss it anyway.
Oh, I've done this before on a different issue a few years ago, and that's exactly what happened. They tossed it, but I was really happy with how more civilized they were acting in court after the grievance.
Funny how that works.
Yeah, it puts it in their place. All right.
It always stings them. And if you sting them early, it makes it easier as you go down the line. Okay, it sounds like you have some experience with these, and that's what I'd like to hear. And I know it sounds like that I'm against lawyers, but I'm not. I understand the position lawyers are in, and I feel for them.
Yeah.
I just can't reach them.
Joke, wow.
It's not about the lawyer. We're not doing this to harm the lawyer. We're doing this to get the system working right. And it's kind of like my grandkids. If they run out in the road, I love my grandkids dearly, but if one of them runs out in the road, I'm fixing to tan his hide. It's not out of anger or meanness or spite. It's the right thing. And you're not grieving these lawyers to be difficult or cause them misery. Now they can go to the judge and say, Judge, I got to do the right thing, because if I don't, this guy's going to sting me good. You give the lawyer plausible deniability.
Ooh, I like it.
Is that a nice rationalization or what?
Very much so. Well, really quick, you've heard that joke why you'll never find an attorney at the beach, at the ocean.
No, I haven't heard that one.
Cats keep trying to bury them in the sand.
Oh, okay. I was just asked today.
That's keeping it clean.
I was just asked today at the sheriff's department if I was a lawyer. Oh, no. I sleep well at night and keep my hands in my own pockets. Thank you very much.
Ooh, I like that. That's a good one.
I filed a writ of habeas corpus for a kid in Conroe. Now, that's down just north of Houston. And they stopped a murder trial to hear the writ. And I get in front of the judge, and I was warned this is the meanest judge in the district. And I get in front of the judge, his name was Montgomery. Stopped the trial, and he looked at my writ, and he said, Mr. Kelton, are you an attorney? Oh, no, Judge. Sleep well tonight, keep my hands in my own pockets. Thank you very much. Well, he didn't take that too well.
Oh, no.
And said that since I wasn't an attorney, he wasn't going to accept my writ. I turned to the bailiff. Mr. Bailiff, did you hear that? Yes, Mr. Kelton, I did. Arrest that judge. Oh, that was so much fun. You haven't lived until you've asked the bailiff to arrest the judge at least once. Every time I've done that, the judge has sat there and kept his mouth shut. Because if he opens his mouth while I'm trying to get the bailiff to arrest him, that's obstruction. And if he says anything I can take as threatening, that's witness tampering. Anyway.
So what happens in a scenario like that? Because I'm sure the bailiff and the judge, they're buddies. They probably go golfing together. They're friends.
Yeah, and the bailiff's terrified of the judge. And I always tell the bailiff when he refuses, well, Bubba, life is filled with little decisions. We all get to make some. Are you going to perform your duty and keep the peace in the courtroom regardless of who breaches it? Or are you going to shield that judge from prosecution? Now, when it gets down to it, which one of you two do you think they'll throw under the bus? Good luck.
Yeah, fine.
Mm-hmm. Okay, we're about to go to break. Do we have any more for you, Ted?
Yes, thank you so much. I'm satisfied. I appreciate it.
Okay, thank you, Ted. Randy Kelton, Rules Our Radio. Our call-in number, 512-646-1984. Mark, Irvin, I see you there. We'll pick you up on the other side. We'll be right back.
They want to chant down Babylon and burn down the whole nation. But them operate the land wrong. I'm a Republican and them a scratch man. Tell them I'm a libertarian. Them say we want to lose, but want to win. Come round.
Chant love rules.
How what we say?
Chant for our wars.
Me tell them.
Chant down by. Chant down by. Chant for this chant.
Always man.
Chant of rule, this chant of chant for our words, chant for our words.
Them when me chant, when me see, say all man was created equally. Chant down Babylon and do it daily. And when night come, pray for everybody. So one by one, me have to chant them.
Okay, we are back. Randy Carlton, Groove Law Radio, and we're going to Mark in Wisconsin. Okay, Mark, I know you've been causing trouble. What have you been up to lately?
Well, I'm thinking about causing more trouble in an entirely different direction and was looking for put your thinking cap on. I'm sure you're aware of the Panama Papers, right?
Yes, I am.
All right. How do I go ahead and get a legal copy of the 2.6 terabytes? I can't figure out a way to get a legal copy, and about the only thing I can do is approach the fine people who run the state of Wisconsin judiciary and say, I want you to declare my getting this as a perfectly legal thing. Then I'd have to go to the feds afterwards.
Okay. I've heard of them, but give me the background on how. I understand they were leaked from a law firm.
That's correct. The documents were taken from a law firm. I'm sure that they otherwise qualify as stolen documents. However, they're now out there. At least
somebody is holding them who didn't steal them.
Correct. And
is that party a public, an official, holding them in some official capacity?
In the state of Wisconsin, I'm unaware of that. But that may be a very good question to ask as a starting point.
Because if they're holding them in an official capacity, either they have been legitimately declared as secret or they're public information.
Good point.
So if whatever governmental agency is collectively responsible to maintain the documents, if they are a federal agency, they fall under FOIA. And if these are papers from a foreign country law firm, has the law firm filed any kind of legal action?
Not that I am aware of, but, I have not dug deeply into the topic. I'm sure they did send out a notice to the account holders saying, if you've got this notice today, you are not part of the leaked set of documents, or we don't believe you've been impacted that badly. If you were impacted, we would have already talked to you. And they did, in that notice, I believe they did the traditional huffing and puffing and going, this is illegal in some way, shape, or form.
Okay, and that may restrict access to it, even if the person who's holding it didn't steal the documents. If they received them from some other party in a manner that did not render them culpable. Even so, if they're holding documents that have the potential to cause harm, and those documents were intended to be secret or confidential, and they were illegally taken, then however you slice that up, you're in possession of illegal documents.
Right. And what I'm trying to do is get to some form of paperwork going, no, in the interest of public whatever, you can have a copy of these documents. And so I'm trying to get from the illegal and get them so that it's legal. And unfortunately, almost all of the paths that I see terminate in, you can't ask us to do anything because, you haven't been harmed yet by being called a criminal and being charged, so then you could appeal to us saying, no, it's perfectly fine.
I'm trying to think of a way that I could legitimately demand access to records that were stolen from someone's private archives.
Right, and I can't figure that. I do like you're a public official, you have a copy, give it to me. I can certainly make those demands, and that is a very reasonable and well-trodden path.
Yeah, and then they have to do something to withhold them, and I suspect they probably would. I can envision where I could hold these papers and not be liable, even though I knew they were taken illegally. If someone gave them to me and I didn't ask for them, say they just sent them to me in the mail, then I can hold them and not be culpable. But when I seek these documents out, knowing that they were stolen, I begin to step in deep water unless I request them legally from a public agency.
Right. And I do like the request them legally from the public agency. I had not thought of that, and that's why I was reaching out to you.
Okay, well, there was a time in open records. I've done a lot of work in open records, especially here in Texas, where I went in and asked, this was several years ago, and they were just beginning to get everything computerized. So there was a lot of confusion, a lot of records I was having trouble getting to. And these agencies are telling me that I can't see these because they're in your computer. I said, well, let me look at your computer. Oh, you can't see what's in the computer. I said, sure can. If you're keeping those records in the computer, then I want to see them. And I got an opinion from the state attorney general that said that either the agency had to run a search on their system, or I could have my own person write the search for their system, and their people could test it to make sure it wouldn't harm the system, and they'd have to run the search for me. But in order for me to do that, I would have to have their software. They jumped up and down and railed, said, this is private software. This belongs to a particular company over here. I said, well, so what? They sold it to the government so that the government could use it to house public documents. I have a right to access those documents. They said, well, these are copyrighted materials. I said, well, if I breach the copyright, that's between me and the company who sold you the software, not your business. And that's what the Attorney General said. They had to release the software. If the company that sold them to them felt I had violated their copyright, then they could take action. But the state could not withhold records in order to protect a third party's copyright. So essentially, these guys are going to say, well, someone else will have a problem with this if I give you those records. Their problem, not my problem. It's certainly not your problem, not your business. So you might be able to get them that way.
Okay.
This goes to international law. Since it's in Panama and to here, that international law is really complex. A lot of things are just not covered. And hacking a foreign private company's database from another country may or may not be illegal. If you're in China, it's not illegal. But China does it.
Well, in fact, in Taiwan, having spent some time looking at these issues, apparently Taiwan and China, it's considered perfectly valid form to attempt to attack the other law firm's computers to gain an advantage.
So there may not, we don't know how the laws are in Panama. It may be perfectly all right to do that, because what you're saying about this firm, the firm looks like they're out trying to put out fires, but I haven't heard them railing in righteous indignation about being robbed from.
No, they haven't. They haven't been railing. It's been quiet up until recently, and of course it's slowly disappearing off of the U.S. news cycles. In other countries, they're having no end of issues over it, but here, nothing in the news.
It may be that the company just wants it to go away and don't want to make a lot of noise. If they try to fight the issues, all they do is make it more public.
Right.
It's not always about the law. That perception is everything.
Yeah, well, why do you think I'm interested in this? It's certainly the law is kind of secondary. It's the fight for the sake of the fight.
You've come to like the fight way too much, I think.
Well,
or maybe not.
It's, at a certain point, it's like, okay, let's see how outrageous the lawyer's conduct can be, and have these people go, oh, there's no problem here. The one of the examples of that from the bankruptcy court, the the one set of attorneys argued that, we can't tell you this information because we're worried about being sued ultimately by the person who's going through the bankruptcy. And we're the ones who own the magic recipe here that's being asked for. I called up the set of attorneys, explained and gave them copies of the modified document that was being used the modified document in a different courthouse. 3 days later, that set of attorneys quit. A new set of attorneys came in, and the new set of attorneys changed the argument entirely and said, no, we only sold the guy raw spices. We don't know anything. And the bankruptcy court, in the interest of just getting the case gone, went, okay. Judge spent 30 minutes grilling the attorney. The attorney just went, nope. Just sold them raw spices. No magic recipe here. Nothing to see. And the bankruptcy judge went, okay, fine, we're done. And, threw it out.
Okay, hang on. About to go to break. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Mark in Wisconsin. Okay, Mark, where are we? Is that the only question, or do you have another?
I was just pointing out the particular case with the bankruptcy. Ultimately, those attorneys shouldn't have made an entirely different argument because they're supposed to review the case and become knowledgeable as to what the client is claiming. And so they had hearings in front of the judge that there's recipes, and then they come in and say no, there were no recipes, it was just raw spices. So at a certain point, I can't say every attorney I met's been a liar, but man, there seems to be a lot of them. And
lawyers, it's their job. It's their job to twist the facts to suit their client's position. So the only time a lawyer is lying is when his lips are moving.
Yeah, that's true too.
But for those of us who know how to sting them, it works. They give us opportunity to sting them good.
Yeah.
So in order to keep them from lying, we just have to give them plausible deniability. If they're afraid that every one of these no-good pro se rascals are going to start filing bar grievances against us, they'll get more reluctant to do that.
Well, two lawyers have up and quit. Once I contacted them and explained the situation to them, they had quit within 3 to 5 days. They said, "Yeah, I'm not touching this." So the more honest ones get out of the way. The less honest ones, well, it's a separate issue, I guess.
Well, you're probably getting the ones that aren't quite so arrogant. And the more we hammer them, the more honest they'll be. I couldn't be a lawyer. Lawyers are afraid of everything. They're trying to make money. We're graduating 40,000 lawyers a year. We have more lawyers in this country than any other country in the world. The U.S. is more litigious because we've got too many lawyers. So the ones that are out there are struggling. So they're afraid of everything.
Yeah.
Then they come across guys like us, and that makes them even more. Now they're afraid of their clients.
Yeah. Well, keep in mind that unemployed lawyers become politicians, so it's always a good idea to pay your lawyer.
You got a point there. Okay, do you have anything else for us?
I'll leave you and have you move on to the next caller. Maybe you'll be able to solve their problems like you gave me a couple of new rabbit trails to run down.
Okay, well, have fun, Mark. Okay, now we're going to go to Irvin in Nevada. Hello, Irvin.
Hello, Randy. I only became aware of your videos on YouTube maybe a few weeks ago, and the ones I see there are you mentioned that the notion that there can be no prohibition if there's no injured party is simply not true. When the penal statute was violated, the state is necessarily an injured party by the violation. By coincidence, my wife and I were trying to bring charges against a notary who was involved in our home from a few years ago. And she basically changed the date not in our presence. And there are various statutes that said, that's a crime. It may be only a misdemeanor, but it's a crime. And when we went to we called the DA's office, and he said, well, I can't do anything unless you take it to the police, and they decide whether it's worth pursuing. And when we went to the fraud department of the police, they kept saying, but how were you harmed? And at that time, when we first visited them, that was just a couple of days before I saw that video of you mentioning that. Now, there is some possible harm, and that this had to do with precision, which I'll hopefully touch upon in a few minutes. But even if it's not the case, the DA said that. We also contacted the Attorney General's office, and he basically said, our limited resources, and we don't get involved in that kind of stuff. Even though in Nevada, they did go after 2 notaries with LPS a few years ago, with like 600 charges of fraud against the two notaries who were in the title company. So my first question is there, do I have some chief?
Okay, let me back up to what the notaries did.
Right.
They changed the date on at acknowledgement.
Acknowledgement, and also on the deed of trust even, which, I figured that's sworn testimony and part of the public record, and they don't have any right to alter or modify it. That's my attitude. But
okay, when you took that as, okay, that's tampering with a government document.
Okay.
I haven't had a policeman ever say something that stupid to me, like, how were you harmed? So, are you kidding me? I'm not suing them. I'm giving you notice that a crime's been committed, invoking your duty to suppress crime like you swore to on your oath you would. And so in Nevada, the prosecutor is saying that the police department has prosecutorial discretion. How did they get that?
That was the DA, Randy. First you went to the DA, and he told us to go to the police. We went to the police.
Okay.
And then I did.
What we're talking about here is practice and policy, not law. And in every state I've looked at, the requirements were essentially the same, except Pennsylvania. And I'll explain that in a second. All criminal complaints, all notice of crime is directed to some magistrate. Not to the police, not to the prosecutor, but to some magistrate. But the prosecutors and the police, they get out here and they try to keep the peace. And they don't always charge someone because they could. They're limited on funds, they're limited on personnel, so they try to pursue the kinds of crimes that cause everybody the most grief. And okay, if you're a policeman, it's understandable that you would do that, because you just can't arrest everybody. So you got to kind of meter your resources. And the prosecutor's the same way. So they have these problems and issues they have to deal with. Their problems, not my problems. My problems, I had someone tamper with a government document to my detriment. And I need this person prosecuted for this act. You don't want to prosecute them? I don't care what you want. So you go to the police officer and they refuse to act on your complaint. The way I read it, that's official misconduct. If it were Texas, it would be official oppression, because we have a special statute for that. But in every other state, it's official misconduct. If a public official fails to perform a duty he's required to perform, and in the process denies you any equal protection of the laws, that's a crime in every state I've looked at. It's also a federal crime under 18 U.S. Code 242. Most every state has a statute that reflects 18 U.S. Code 242. So the way we get them to do their job is, I go to the police. I went to the police recently in Parker County, Texas, just west of Fort Worth. Actually, yesterday I called the sheriff's department, asked for a supervisor, and got a sergeant and asked him to arrest the assistant warden for the Parker County Jail for obstruction of justice and official oppression. And he refused. He refused to take my complaint. He said, you need to talk to the jail. So I can't talk to the jail because jailers are not peace officers. They can't take criminal complaints. And well, I finally asked him, if I bring a verified criminal affidavit, will you refuse to take it? Well, you're going to have to talk to the jail. Okay. 2 hours after I talked to him, the assistant warden went to the woman in jail they were not allowing access to the court and gave her access to the court. So that tells me the sergeant talked to her and conspired with her to shield her from prosecution by getting her to go fix the problem that all this had caused. Hang on, I'll tell you how we handle this when we get back. Randy Kelton, Rule of Law Radio, our call-in number, 512-646-1984. We'll be right back.
You've heard of hairspray, but how about DNA spray? It's a high-tech way to catch robbers, but down the road, it could be abused. I'm Dr. Catherine Albrecht, and I'll be back in a moment with what you need to know about aerosol microdots.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Exploding ink can cover thieves in a profusion of purple, but nowadays they need to look out for spray-on polka dots the size of pinheads, too. The Selectamark security system uses DNA spray on robbers as they make a getaway. The coating glows under ultraviolet light for weeks, and police can identify the crime scene because the spray contains unique microdots. While it's currently used to nab criminals, the spray could be turned to other purposes. Imagine attending a political rally and later glowing under ultraviolet light at the airport. It could give a whole new meaning to the no-fly list. Maybe we should all be wary of DNA spray. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free Tolly? Who you want chip? Me no free Tolly. You can't chip me. What I'm saying? Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And then when you go computer reading, you can't.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio. And we're talking to Irvin in Nevada. In handling these guys, one of the things we need to do is change our perspective. We go to these public officials and ask them to do what the law requires them to do. And they do what they want to do. They do like what they feel like they need to do. Well, I don't really care what they feel like they need to do. I care what the law says. So to keep from feeling betrayed by our public officials and mistreated by them, we take a whole different approach. See, when I go into a courthouse or a public building, I am the baddest motor scooter in the building. And there's only one reason I'm the baddest motor scooter in the building. It's because I'm not a judge, a prosecutor, a bailiff, a clerk, a police officer. They're all public servants. They're the servants. Me, I am the master. And they are not to forget it. When I, as the master, go in and invoke the duty of one of my servants, they will either perform their duty or I will go to the next official in line and invoke that official's duty to arrest the first one. And then when that one refuses, I'll go to the next one over him and invoke his duty to arrest the second one. It's all politics. You'll never win your case simply because you have the law and the facts on your side. It doesn't work that way. You only win your case if you have the politics on your side. Police are not going to enforce the law just because somebody broke the law. They're going to enforce the law because they have to. They're going to enforce the laws that are most important to that policeman and his personal political position at the moment. He's going to do what his boss wants him to do. And if that's blowing you off, he don't care. So what you do is you go in there and take them to task for not doing what the law requires them to do. We need people doing this. We pay our policemen and send them out to police us. We want them to police us, to keep us from losing track of what's important, to keep us from indulging in our distraction. We don't run that red light, not because we think somebody's likely to sneak around the corner and smash into us and kill us. We don't run that red light because we think there's some dirty, rotten scoundrel cop parked right around that corner waiting to nail me for that. And in that way, they protect us from ourselves. We owe them the same courtesy. Yeah, I have to sting them on occasion. But life is tough. I filed criminal charges against public officials with the grand jury. But I'd never want one of these guys indicted. But then I didn't want them to do anything that would give me cause to file against them either. So, sorry guys, life is tough. When you start thinking of your officials in that way, everything changes. You get a lot better results. And our officials, they find out that they have to pay a whole lot more attention to you and I as ordinary citizens because we can sting them good. So with all that said, Irvin, what is it that you want to accomplish?
One of the things I neglected to mention, the notary in question, we did go to the Nevada Secretary of State to complain about her, and she sent a copy of her notary journal showing that the documents were signed on the date that she said, not on the date that we said. And we think that the journal has been tampered with. It was like it's photoshopped pretty crudely. But again, she sent a copy. So, I mean, if we got into a lawsuit, we might have to go through discovery and all that. But if we file a criminal complaint, we assume that law enforcement people can get hold of that pretty quickly and do a pretty simple test. So we want to be able to press charges. I don't know whether we should try to go to the chief of police or kind of sign me here.
Okay. I suggest the first thing you do is write up a statement of facts.
Yes.
And here's how you create a statement of facts. You start out with a timeline. This happened and this happened and this happened. No explanation, just what happened and when. Once you have a timeline down, then go back and start filling in facts. And it's difficult for a non-professional to write a statement of facts because it's hard for us to separate facts from our beliefs or opinions about those facts. So a really neat way to do that is write down a fact and then end that sentence with, in my opinion. If you append, in my opinion, to the end of the sentence and it makes sense, scratch it out. It's not a fact. If it doesn't make sense, then it's most likely a fact. So get a statement of facts. There's kind of an art to this. It looks like just bare facts. They did this, they did this, they did this, they did this. But when a human being reads your statement of facts, they're going to try to fill in all those explanations that you didn't give them. So once you have all of your facts down, now you go back and construct a story explaining what happened. Then you go back and look at your facts. Which facts, if a person read them in order, would lead them to the conclusions that you want them to come to? Which facts would tend to either distract them or confuse them? Take those out, unless they're material. If they're material, then explain why they're not important. But try to lay the facts out in a way so that when a person reads them and they draw logical conclusions, they'll tend to come to the conclusions that you made in your statement. That way, we assume this is written for a judge. The judge reads the statement of facts first, and then he reads your argument in support, your statement of factual accusation. And you come to the same conclusions he came to, and he thinks you're really smart. And he will tend to accept what you say. So start out with a good statement of facts, and then write a criminal affidavit, a criminal complaint. You can go down and look in the criminal courts and pull any criminal case and look at an information. An information is a document that a prosecutor writes when he gets a complaint. A complaint is intended to be received from a private citizen, non-professional. The lawyer then takes that complaint and writes it in the form of an information. And what the information is this is technically how a complaint should be written. So look in a criminal file and pull out an information and see how it's styled. And just change information to complaint. And then write up a criminal complaint and take that to a police officer. Okay, what that does is You give notice to the officer that a crime has been committed. You're not asking him for his opinion. If you're above the age of 18, never been convicted of a felony, you are a credible person by legal definition. So when a credible person makes it known to a police officer by way of a verified criminal affidavit that a crime has been committed, it invokes the officer's duty to take that complaint and give it to some magistrate. But he's not going to do that. He's only going to give it to the magistrate if he thinks it should be prosecuted. Well, that'll work. When he doesn't give it to the magistrate, then you make up a complaint against the officer for not acting against on the complaint against the original actor. Now, the officer's going to be real unhappy. We'll explain the next step when we come back. Randy Kelton, Deborah Stevens, Rules Law Radio. Good evening.
Hello? Oh, man, in jail? You got busted, man? Oh, man, I'm broke, dude.
Okay, we are back. Randy Kelton, Rules Law Radio. And we're talking to Irvin in Nevada. Irvin, this is a process. If you want them to go after the notary, you've got to give them a political reason to. So you kick the officer by filing against him with somebody over him. And then when that person tries to protect the officer, you go over him. See, we're the masters. We're the CEOs. Everybody answers to us. They just don't want us to know that. And as you start working your way up the line, the heat gets on. It creates politics. In the case I mentioned earlier, calling the sheriff, the phone's lit up immediately as soon as I got off the phone, and this assistant warden couldn't get down there fast enough to get this problem fixed because they knew they had their master coming after them, that there wasn't anybody in line all the way up to the Attorney General of the state of Texas that could do anything with me. I crawl right down their throats. I have filed criminal charges against the Chief Justice of the Texas Supreme Court. I got all the judges of the Court of Criminal Appeals put before a grand jury and only got that done because I'm nobody. You can do that. If you want to get them to go after this notary, you got to give them a political reason. And you take this police officer and you kick his boss's boss. Erwin, you ever been in the military?
No.
Okay, well, in the military, poop rolls downhill. And the further it rolls, the bigger it gets. If you're the one that got this mess started, they don't care if you were right, wrong, or what have you. They just do not care. You caused this problem, fix it. Does that make sense?
Yes. I've seen a bit of that philosophy in some of the videos I was fortunate enough to see of yours, but not and seen many of them. Well, the second question I have, if I may, has to do with you. In another video, you mentioned going in a foreclosure situation, instead of going down the rabbit holes of MERS and this and that, going for the breach of contract. And I was wondering if that's still viable when the broadcast came. But also, you mentioned TILA and some other organizations.
Hope Atila RESPA.
Yeah. Well, since then, I think that was the one I saw, maybe 2012. I assume you're aware of, let me see, for starters with TILA, the Jasanowski decision by the Supreme Court a few years ago, in January 2015.
Am I ever aware of Jasanowski? Oh, I couldn't believe that Wells Fargo let this thing get to the Supreme. What were they thinking? Jasanowski, this couple gets a loan, and then 3 years after they get the loan, they file a notice of rescission. And what they claimed was, they didn't claim that you didn't give us notice that we could rescind.
You had to take the lawsuit.
They claimed that you only gave us one, and there were two of us sitting here. You were supposed to give us two. And they filed it on the absolute last day. That was about as nitpicking a complaint as I could imagine. They didn't say you didn't give us notice, but you were supposed to give a paper to both of us. And they let this get all the way to the Supreme, and the Supreme just mopped the floor with the banks. I have 2 quiet title actions in court right now. Here's what we did. I got this qualified written request. Now, a qualified written request is a document that claims an accounting error and requests that the servicer correct the error. So I just take all of the amounts on the HUD-1 settlement statement and say, guys, at closing, you didn't provide documentation to show that these fees were valid, so therefore they're all fraudulent. Prove them up. And I claimed that these were fraudulently charged, and therefore you're charging too much on the payment demand. You need to correct the accounting error. That makes it a qualified written request. And then I dispute the entire debt. And then I do 20 pages of trash. I got 20 pages of discovery. And if you look on the internet, you find these qualified written request documents. All they are is discovery. It's not a qualified written request, and the lender doesn't have to respond to any of that. But I put it in there anyway. And the reason I put it in there is the very last paragraph. It says, if you fail to adequately respond to this inquiry within the time allotted, you may consider this document as a notice of rescission. They never read it. They get to all of that garbage discovery and say, this is trash, and they don't read the last paragraph. So they got 20 days. And what I'm claiming is the statute says you have 3 years to rescind. After that, you're barred by statute of limitations unless you're in foreclosure. Yep. Once foreclosure begins, if you can show more than $35 of unnoticed charges, your right to rescind renews. We had a judge just last week render a ruling that our rescission was invalid because we didn't rescind within the 3 years, and the right to rescission doesn't last forever. And I wrote a response and said, yes, it does. Once foreclosure is initiated and you can show more than $35 of undisclosed charges, the right to rescind is reinvigorated, and there is no statute of limitations. So it does last forever. But on the first 3 years, if you file after 3 years, the statute of limitations, the argument we're making, is not a bar to filing. It's an affirmative defense. And when you give notice of rescission, they've got 20 days in which time to bring that defense. File an action with the district court in opposition to the rescission. Jasnowski says that the Truth in Lending Statement, the Truth in Lending Act establishes you got 20 days. If you don't begin the rescission process or file an opposition in the district court, the borrower may retain the property with no further obligation. So we're saying that while you had an affirmative defense, you had to bring it. Since you didn't bring it within the 20-day time limit, you waived it. Oh, we're having great fun with this.
Supposedly, they're supposed to give back the canceled note and all the money, and even closing costs should give, like that'll never happen, as well as reconveying the property. But we have one in our state, and we got the 3-day limit by 4 days in March of a year ago. We got arguably the worst federal judge in the country, Judge Robert Jones in Nevada. He's been overturned by the Ninth Circuit like 2 or 3 times in the last year and a half, and just last month in March, he was taken off a case with one of those grazing things with the ranchers. Anyway, he's turned down everything, and we're appealing to the Ninth Circuit. But just to show you how bad a judge he is, there's a situation when he used to be the judge for Nevada, the head judge in Nevada, and he asked the head judges for all 50 states to sign something regarding sequestration. 49 judges voted yes. He was the only one who said no. And he's just crazy, so we're hoping the Ninth Circuit...
Okay, hold on. Everything's political, and all politics is local. You will never win your case simply because you have the law and the facts on your side. You'll win your case if you have the law, have the politics on your side. And it sounds like this judge is very political. You should grieve him. You should file a judicial conduct complaint against him.
Here's why, Randy, because he was appointed by the senior Bush, and he just turned 65. As of February 2nd, they said he is going down, he's getting rid of 65% of his workload. But he still gets full pay. Nice work if you can get it. However, he's keeping the cases that he has, because once you get to be 65, which he's like 67, and worked 15 years, then retirement is looming. So he's been appointed for life. He doesn't give a rat's ass, and He obviously doesn't mind being reversed, like I said. He's been reversed at least 2 or 3 times and represented.
Okay. Listen. The only way we know of getting rid of a judge is getting his bond rating so high they can't afford him. And the way you do that is you file judicial conduct complaints against him. And if he's a federal judge, that's like a lawsuit you file with the Court of Appeals. That is very, very, very political. It gets everybody looking at the judge. They hate judicial conduct complaints.
What conduct? I'm sorry, I'm hard of hearing. What kind of complaint is that?
Judicial conduct.
Oh, judicial conduct. Okay, I thought you said judicial
yes,
conduct. What the hell is
ding him good.
Judicial conduct, right? Yeah.
And if he says one word about you filing a judicial conduct complaint against him, you charge him with witness tampering.
Got you. I get it.
I'm working on a 89-year-old judge we've got here in Fort Worth that we really need off the bench. And I'm working on him. Okay, if you have more for us, Irwin, call us back tomorrow night. We do a 4-hour show, but tonight we are out of time.
Perfect.
Charles, I'm sorry I didn't get to you. Give us a call tomorrow night. We'll get to you tomorrow. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. We also have a listen line on Logos Radio Network. You can go there and listen to us live. We'll be back tomorrow night with our 4-hour info marathon, so give us a listen. If you got any questions or comments, give us a call. Thank you for listening, and good night. Dangerous.